Okay.
Alright, so apparently we're not able to get that done today.
Nope, no, I can't do it. We don't know, I mean, I don't know how long it's gonna take, and I don't want to just keep waiting indefinitely. We're trying to, put it onto one continuous flow,
Right.
so that obviously it would be, we're not fast forwarding through and so
Right.
forth, so, we could probably play it, but it would be in that fashion, and that, you know, I know the way the court wants it, so he's working on it now, and he could have it done, but we just don't have a time frame. It could take 30 minutes, 45 minutes, an hour, and so it's just too long and too.
So.
What I would rather do with the court's permission is, just do, if the court's gonna allow our investigator to testify, then to do him today, and then, you know, unfortunately I apologize for Detective Bachman, but we would probably need him back for the playing of this when we come back.
So, let's see where we, so Monday the 13th?
Sure.
Right. So with regard to the issue of the defense investigator testifying as to efforts to locate 2 or 3 witnesses, I've looked at all the cases that have been cited, and I don't think, oh, come on. Yes, I have it here. Okay, I don't think any of them are directly on point. Case of People versus Erickson, 254 Calat 2nd, 395, cited by the People. Dealt with it was a drug case, and the defense wanted to subpoena an informant who basically just made an introduction, but wasn't material on the issue of guilt. And the judge said, I'm not going to permit the witness to get up here, relate a lot of irrelevant matter about where he went, why he went there, and who told him what. It has nothing to do with the issues. And then the court said, you're not going to be permitted to manufacture and present irrelevant evidence. And the issue that went up on appeal was the defense claimed that the judge accused the attorney in front of the jury of attempting to manufacture evidence. And the appellate court said, no, the judge didn't really do that. And there was also, there was a proposed stipulation to the effect that either neither side or the defense never had the address to subpoena the witness. And the appellate court said that the judge was not accusing the defense attorney of attempting to manufacture evidence, but properly sustain the objection to irrelevant evidence. And obviously there's a different issue between an informant who's not material on the issue of guilt from this case. Then the defense also, the prosecution also cited People versus Galvin at 208 Calat 2nd, 443. I think that's another informant case. Yes, that was also an informant informant, drug case informant. Informant was present during a transaction between the officer and the defendant, and there was a claim of entrapment that the informant approached the defendant to sell the drugs to the officer. And there was a delay between the offense and the arrest so that the informant can complete investigations on other cases, and in the interim, the informant had left the area and was now unavailable. And in that case, the defendant was aware of the identity and location of the witness, of the informant, at the time of arraignment, but made no effort to contact him or subpoena him until 2 days before trial. And then the defense wanted to put on evidence as to the efforts they did 2 days before the trial to locate him. And the court said the defense has made no showing that by exercise of reasonable amount of effort, he could not have secured the presence of the informant as a witness. Defendant's own lack of due diligence contributed to the circumstances about which he now complains. The record reveals no excuse for the failure to attempt to locate and subpoena the informer earlier. So that's clearly distinguished from this case. This is not a situation, well, it's not that situation where the defense didn't, although they didn't do it until earlier this year, there was obviously reason for them to believe that at least one of the witnesses would be called by the prosecution. Then we have People versus Leppy, 57 Cal. 4th, 977. That had to do with a situation where a witness testified at a preliminary hearing, and the witness was not available at trial. It was the prosecution who wanted to use the witness's earlier testimony, so they had to show that, number one, the witness was unavailable, and number two, they had to show due diligence in attempting to locate and secure the witness for trial. So in their duty of due diligence, they were able to put on the evidence as to what they did to try to locate him for due diligence. That case has some interesting holdings in addition to the issue of the due diligence that will come up in some relevance later. But obviously the issue of district attorney needing to make a showing of due diligence to locate the witness is different than the situation here. So again, that case doesn't apply. And the two cases cited by the defense also were not applicable. People versus Vaughn at 262 Cal. 2nd, 42. Had to do with NGI proceedings and MBO proceedings and writ proceedings, and it's not applicable here. People versus Reingold, 13 Cal. 3rd, 711. that also dealt with preliminary hearing and a showing of due diligence, so, that's again not particularly relevant here. So, what?
In the Lepe case, Your Honor, and I was listening to the court's ruling that there's an entire section regarding the relevancy of efforts to find someone, and the pinpoint sites are on page 987. And the defendant was arguing that the trial court erred in refusing to admit testimony as to why the witness was unavailable.
That's a different issue, and I agree that why the witness is unavailable is a different issue than efforts to locate. I agree with you on that.
Okay, then what is the relevance of this testimony? We had a proffer from the court. We haven't heard from the defense under 403.
I think they're entitled to show that there are logical witnesses suggested by the evidence that they might have called, and I think they're entitled to put on evidence to show we tried to locate them to get them here, we were unsuccessful.
Okay, then are they precluded from arguing that he's hiding?
Yes, I agree with that, they are. I think,
Are they precluded from arguing that Mr. Kavanaugh prevented the presence of Mrs. Rivaconi?
yes, all of that is speculative, and the Levy case, as I indicated, addresses those issues. It said the trial court held that the testimony as to the reasons for the witness's unavailability would be speculative, since no one has spoken to him and knows what reasons he might be unavailable. So the reasons a witness is unavailable is speculation and would be hearsay if someone would offer that.
But allowing the defense to.
Just a minute. And it was on that basis that the court in Levy said there was no abuse on the trial court's discretion under Evidence Code 352. What the court in Levy indicated was the efforts of the officers to locate, this was again the prosecution, I think attempting to show due diligence, right?
No, it was the defendant attempting to show testimony as to why the witness was unavailable. That's on page 987 under alleged exclusion of impeaching evidence.
Well, okay, we cannot say the trial court erred in making this ruling. The efforts of the officers to locate Mr. Mercado would not shed light on his reasons for failing to be available to testify. And there was a separate issue of, since his preliminary hearing testimony was read to attack his credibility, and that's not an issue here. So I think the defense is entitled to call their investigator to say, I went to what in the discovery was his last known address to attempt to serve him a subpoena. He wasn't there. I attempted to locate other addresses where he might be. I couldn't locate him.
And so the court, implicit in that ruling, is forbidding either side to make in closing argument the argument of failure to call a logical witness as to Mr. Kavanaugh. Because it would be speculative.
Yes.
And so if it's speculative, then it's not relevant. The evidence of it would be not relevant.
I think they're entitled to put on that they attempted to locate him.
We would also
But that's it. It's limited to that. They're not going to be permitted to argue Kavanaugh's hiding, he's running, his consciousness of guilt. They don't need to do any of that.
So the court's making that specific ruling as to closing arguments.
Yes.
And
because that would be speculative, there's no evidence to support that.
And we're also objecting to any questions along the lines of what tools did you have as an officer to locate people that you don't have as a private investigator? We're objecting to any questioning along those lines.
We can say anything he did, I mean, if he ran a DMV check, if he did.
Well, there's a distinction between what could you do as an officer and what databases did you have access to that you don't have access to as a private investigator. Because that leads to the argument that they didn't even try to find him and we did. And that's not relevant.
Well, it also.
Correct.
All they're entitled to do is put on evidence of what Mr. Robertson did to try to locate him. Not what someone else might have been able to do. That's not relevant.
Thank you. Okay.
So if Mr. Robertson says, I access DMV database, I access whatever, okay, and you couldn't find him, okay.
Okay.
But I would preclude any argument or inference being made that that means the witness is running or hiding or consciousness of guilt or anything like that, because that would be sheer speculation. I mean, it might be Mr. Robertson's just not that good and couldn't find him where someone else could have found him easily.
But that's what's implied by allowing this testimony.
No.
And if the court allows this to happen, then what's to prevent any other defense attorney in the future from standing up and doing this? To point the finger at somebody else, which is what they've done the entire trial, and now to allow testimony that says, hey, we couldn't find him. And the problem that I have, Your Honor, is once that bell is rung, the defense in this case has repeatedly violated this court's order with respect to third-party culpability. And unfortunately, I wish that the court could sit there and say, this is my ruling and this is only what you can argue in closing and you're not allowed to say this. But we know that that hasn't been followed.
Well, if that were to be violated, I would definitely correct the situation in front of the jury.
But that's happened already.
Your Honor, I'm not gonna sit here and listen to them talk about us violating court orders when that's all they have done this entire trial. So I don't wanna get into that argument with them. They're not only violating court orders on a daily basis, but they've done so throughout the trial.
Well, that's,
Okay, well, that's an
So that's-
accusation of misconduct, let's have a hearing.
We need a hearing right now.
that's not.
That's their go-to line, let's have a hearing.
That's not the.
I can assure you, Your Honor, there will be a hearing.
That's not the issue before me now. The issue before me now is, are you entitled to put on evidence that you attempted to locate these witnesses? Yes, you are. You're not entitled to bring out any evidence that anyone told him. So if he went to a location and someone said, oh, he left a long time ago, he's hiding out in, wherever, you don't get to put that on. I went here, I tried to find him, go in there. Okay?
So to be clear, is the court allowing testimony from Mr. Robertson as to all three of those witnesses?
Sure.
Then we'd like a 402 on that, please, Your Honor.
And I think we're also entitled to a hearing if he's alleging we're violating court orders on a daily basis.
I'm not going there now. I'm gonna deal with the issues before us.
There have been some misrepresentations made to the court with respect to those three witnesses, and we would like a 402 on that, Your Honor. The information that I understand, and if I'm wrong, I'm sure I'll get corrected, but the information that I understand that was presented to this court was that those three witnesses were unable to be subpoenaed and located by the defense.
I believe that's what the representation was this morning.
Yes, I
We've been provided with information that that is not a correct representation. So we would like a 402 on that, Your Honor.
Okay. You ready to proceed with that now?
It's his
Yes.
burden. He's the proffering party.
Why is it that we have to do a 402, Your Honor, to give him They have the report on one of the witnesses.
Well, let me see Mr. Robertson's report.
The one that only covers Mr. Kavanaugh, not the other two witnesses.
Okay, so this report only addresses Kavanaugh. So there's no discovery as to the other witnesses as to what was done.
That is correct. There's the Lauren Knowles, which is one of the prior girlfriends for Kavanaugh.
I'm not going to permit you to put on any evidence if you haven't provided discovery.
Okay.
So you can call him as to his efforts to locate Mr. Kavanaugh based on the report.
That's fine.
Okay. So we can do that now? That should be short, right?
Yes.
Okay.
We will be providing a discovery to the court in terms of, not to the court, to the people regarding the other two witnesses, and we'll be calling Mr. Robertson back for that.
Okay.
Your Honor, if we could have an offer of proof as to those other two witnesses, we could probably just do it today. The representation this morning was that a witness couldn't be located, namely Tracy Riccobini.
That's not the representation that was made,
Yes,
not by me.
Read the transcript, Your Honor.
It's in the transcript.
And I believe that's what I just represented to the court as to what our understanding is.
So this is just delaying everything. And this, at this point, all we've done over the last 2 weeks is reiterate everything that the jury already knows. We know Joseph had a waterfall business.
I agree. I
Okay,
agree.
so if you agree, can you please stop it? This is cumulative.
Your Honor, you don't think you allow this conduct to go on? I mean, you allow a prosecutor to sit up here and say these types of things on a regular basis? I mean, it really impedes the
I've
ability.
allowed both of sides to say things and do things that were improper, and making allegations that were either partially true or not true at all. And we could certainly sidetrack the entire trial and have a whole trial just on the conduct of counsel. That, of course, would be to the benefit of the defense because we would never finish the trial. So I'm not going to do that. I'm going to keep the focus on the trial and let others deal with misconduct of counsel at a later point.
Well, I think that's the point Mr. Dowdy's trying to raise, is that these are starting to appear like intentional stall tactics, where you don't have experts completing work until the night before they testify, even though they've had the case for 3, 4, 5 years.
Can you
Then
imagine?
also,
Can you imagine who's saying this, Your Honor? I mean, can you really imagine?
Well, every expert that the defense has called has provided their report the day of or the day before they testify. Everyone.
That's, Your Honor, our accountant provided it in July.
All right.
I'm
I'm not
not,
getting into, I don't care what was done before. Once again, every issue that comes up, you want to say, well, they did this and they did this and they did this, so that we should get to do this.
Why are those comments directed at us? Why shouldn't those comments be directed at the prosecution, who hired an expert in the middle of trial?
I think they're directed at you because they're more often than not more appropriate to your conduct.
Well, I disagree, Your Honor. And the court is saying that after their expert from Canada, Mr. Licio, was hired in the middle of
I'm
trial.
not gonna litigate every issue.
But I think, Your Honor, for the record, what I was trying to complete was, we took almost the entire month of March off due to their scheduling of witness issues. Now we've taken what is mounting to gonna be two and a half weeks off for Mr. McGee
Well, 4 weeks.
versus Mr. Moline's preparedness, which I sincerely question, considering I happened to be at a social event with Mr. McGee on Saturday where he was perfectly fine drinking and dancing. I'm starting to question that these unpreparedness with the video, getting a witness here, repeating fact after fact after fact that is cumulative to the people's entire case in chief, and the defense's cross-examination of it, is starting to appear like stall tactics, intentionally done. Not that it's a preparedness issue, because Mr. Moline on several occasions has shown himself to be competently prepared to handle a handoff witness such as Mr. Stutchman, to deal with last-minute issues that come up. And I think the court, at Mr. Dougherty's urging, needs to control these proceedings a little bit, because we're going to start losing jurors and we will end up in a mistrial because of that. And that's what it's starting to appear like.
I agree with that.
And-
And I think we're at a point where we are just about finished. Defense told me a while ago that once they were done with whoever the last expert was, other than Dr. Rudin, you were done. And then it's, oh, but that doesn't count the law enforcement people we want to recall. So we have, 4 or 5 of those we want to recall for basically repeating what was done in cross-examination. So we are at a point where we're going to finish one way or the other on the 21st. If Mr. McGee's not able to go, then Mr. Moline will have had 4 weeks to prepare by then. And he can finish with or without Mr. Rubin,
If this
with
is,
or without opposing argument.
I'll, Your Honor, whatever the court says in terms of what we have to do scheduling wise, I've already told the court on several occasions I will abide by those, even if it means that I have to do that. So if I have to do a witness, I'll do it. If that's what the court's order is to finish on a certain date, I will do it.
I
Okay?
understand.
So I've already offered that up. So every time we discuss these issues, the prosecution goes into the 3 of them get up like cackling schoolgirls and go through this thing that we're engaging in some type of misconduct, and the court allows it to occur on a regular basis. So should we just sit down and not say anything when they throw that out?
It seems to me that both sides are more interested in attacking opposing counsel than they are in representing their respective clients. I think both sides, if given the choice of putting on evidence to support your side or to attack opposing counsel, your first choice has been to attack opposing counsel and then try to work in the other evidence. I guess you think that's effective with a jury. I question that tactic, but if that's your tactic, so be it. But I'm trying my best not to get drawn into that because, again, I'm trying to keep the focus on the trial, not on constantly having hearings to address the misconduct of counsel during the course of the trial. So, if you want to call your witness for his efforts to locate Mr. Kavanaugh now, you can do that.
And again, my original point was, can we just have an offer of proof?
Can
as
we
the other
just
two?
tell him to sit down and we're done with the issue? Does he have to keep going on
Okay.
and on and on?
Then you're waiving the testimony of the other witnesses?
I'm not waiving that. I'm saying that we're calling Mr. Robertson now. They are saying that they don't have a report for the other two witnesses, and we'll get them a report, and we'll ask the court to recall Mr. Robertson before the 21st. I mean,
Can
what
we
else?
just have an offer of proof, then we can just do it today?
Well, I was beginning to explain, and Mr. Robertson went to, I forget the town up north, that is to find Lauren Knowles. That's the girlfriend of Mr. Kavanaugh.
I think we should have a report from Mr. Robertson rather than,
That's fine, and that's what we'll do.
so,
So today we'll have testimony regarding Kavanaugh. They
okay,
have a report, and that's what we'll do.
okay.
Your Honor, just hold on a second, if you may.
We'll just put them up.
Just let him testify, Your Honor. I mean, the court's deemed it to be relevant. We'll deal with the misstatements of counsel and Mr. Robertson's thoroughness of work when he testifies on cross-examination.
I'm glad that we got his approval. I'm glad we got the prosecutor's approval for that.
That's called withdrawing an objection,
Yeah, okay.
Your Honor. We've
Thank you.
withdrawn our objection to
Okay.
request
Thank you,
402.
thank you that we got his approval.
We can bring the jury in.
Sounds good.
Alright, the record reflect we are back in session, parties and counsel are present, and members of our jury are present. Apparently, we were not able to get that onto a single disk or thumb drive that quickly, so, we're not gonna be able to do that today, we're gonna have to come back on, Monday, the 13th, everyone's available as far as I know, right? Yes. Okay. There is one other witness, that can be called at this time, so Mr. Marine, you can call your next witness.
Thank you. Gary Robertson?
Do you solemnly state the evidence you give in these matters the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name, spell it for the record.
Gary Robertson, G-A-R-Y-R-O-B-E-R-T-S-O-N.
Okay, you're,
Thank you. Good afternoon, sir.
Good afternoon.
What is your current occupation?
I'm a private investigator, licensed through the state of California.
And when did you become a private investigator?
March 31st, 2016.
And prior to becoming a private investigator, what did you do?
I was a police officer for the city of San Bernardino for 35 years. I retired out of that department medically as a retired homicide sergeant.
And in your job as a police officer and also as a private investigator, were you, well, let me ask you, as a police officer, what did you do as a police officer, and how did you end your career, in what assignment?
Well, I started off working patrol for like 8 years, and I went to narcotics for about 3.5 years. Got promoted to a training officer, then became a detective in the homicide, or the investigations unit. I was there as a homicide investigator for probably about 14.5 years. Got promoted to sergeant, stayed in the field for 2 years, and then I went back up into the investigative unit at the police department, where for the first year I was a child crimes, persons crimes sergeant, and then for the remaining 4 years of my career before I retired medically, I was the homicide sergeant.
In those capacities as both a police officer in law enforcement and as a private investigator, was part of your job locating witnesses?
Yes.
Would it be fair to say that sometimes that can be challenging?
Yes.
And how long have you been working on this case?
I was given this case to help in the investigation back in April of 2016.
So that would have been shortly after you became a private investigator, is that correct?
That's correct.
And was one of the assignments that you had, well, I take it you had several assignments in this case?
Yes, I did.
Was one of the assignments identifying and serving subpoenas on witnesses
Yes.
and locating witnesses?
Yes.
Were you, were one of the witnesses that you were assigned to locate and serve with the subpoena, Dan Kavanaugh?
Yes.
And when were you given that assignment?
I think my initial assignment with him was back in August of 2017 to try and locate him and serve him some, well, subpoena for some paperwork.
Okay, a subpoena for paperwork or?
Subpoena dues tecum.
Okay. Do you recall what that was?
No, I don't.
Okay. Were you successful in August of 2017 in locating Mr. Kavanaugh?
No, I was not.
Did you make any other attempts at that time to serve that subpoena ducis tecum?
I went to another location on that same day to an Escondido address.
Okay. So now a subpoena ducis tecum is different than a subpoena, is that correct?
That's correct.
And what's your understanding of the difference?
In a subpoena dues tecum, my understanding is that the individual is supposed to either appear in court with some certain paperwork or get it to the attorney requesting the paperwork prior to the court date.
Okay. After August of 2017, were you given another assignment to serve a subpoena on Mr. Kavanaugh?
Yes.
And when was that?
Middle to late August of this year, 2019. Or, no, I'm sorry, February 2019.
And was that a subpoena ducis tecum or was that a subpoena to appear in court?
A subpoena to appear in court.
And the trial started in January, and why did you wait?
Objection relevance.
Sustained.
Prior to February of 2019, did you attempt a regular subpoena on Mr. Kavanaugh?
No.
Was Mr. Kavanaugh, as far as you knew, on the prosecution's witness list?
Objection relevance. Move to strike.
Sustained.
What efforts did you make to subpoena Mr. Kavanaugh in February of 2019?
I went to seven different locations, from San Diego to Irvine to Lemon Grove to try and locate him.
Did you start in the San Diego area on February 23rd? Was that the first time you attempted to locate him?
Yes.
Okay, and then when was the next?
Well, I made 2 attempts to locate him on February 23rd.
Both in the San Diego area?
Yes.
Okay, and what about after that?
The next one was in Irvine
When was that?
on the 24th of February.
Okay, and were you successful there?
No.
Okay, and why did you attempt in Irvine?
When I looked up his Facebook page, I saw a mention of a company there, and so I decided to see if I could find him at that location.
And did you continue your efforts after that?
Yes, I did.
And when was that and what did you do?
On Can I refer to my report, make it
If it
accurate?
refreshes your recollection.
Yes. On March 1st, 2019, I went to another address in San Diego on Redwood Street to try and locate an associate of Mr. Kavanaugh. No one was home. I left the card asking for a call back.
Okay. Did you get a call back there?
No.
And what did you do next?
On March 21st, I went to an address in San Clemente on Avenida Granada, Unit 3, and determined that that was a bad address per a neighbor. So he did not live there.
During this time, are you also checking other sources, like you had mentioned Facebook before, social media outlets and so forth?
Yes, I was randomly checking the jail database systems to see if he happened to be placed into custody. I did that several times prior to my attempts on a subpoena and during, obviously, my attempts to get him subpoenaed. I never found him to be in custody during any of those attempts.
Okay. And were you able to tell whether or not he had I guess a website or any type of social media presence where you're able to find out maybe his location from that angle?
No.
What about efforts after the San Clemente address? Did you try again after that?
Yes, I did. I went to the Redwood address again, the female associate of him. Again, no response. Left a card, left phone numbers for a call back. I never got a response.
And after that?
After that, I received information that he may be frequenting 2 different locations, one in Lemon Grove and one in San Diego.
Are you using your skills that you developed as a police officer to track Mr. Kavanaugh?
In my capacity as a private investigator, my resources are
Objection,
Sustained.
non-responsive.
Sustained.
Well, you mentioned that, or you mentioned in your report that there was, I guess you referred to it as a citizen informant.
That is correct.
And why would you talk to a citizen informant?
I had received information that this individual may have information concerning Mr. Kavanaugh.
So it's not that you're just going to addresses, you're trying to get information about where he could possibly be.
That's correct.
After the March 21st attempt in San Diego, what did you do next?
I then went to an address in Lemon Grove, which is, I guess, a part of San Diego, on April 12th. And sat on it, watched it for a while, no response whatsoever, and I left at that point in time.
Are these addresses that you're getting from the citizen informant?
This particular address was given to me by a citizen informant.
Okay.
I had actually 2 addresses that he supplied me with.
Are there online tools that you're using to locate potential addresses for Mr. Kavanaugh?
No,
Did you request any updated addresses from the district attorney's office?
yes I did.
And when was that?
That was on March 3rd, 2019. I made a request to the district attorney's office for their most current address on Mr. Kavanaugh.
Did you get a response?
Yes, I did.
Okay. When did you get a response?
It was quick, either that day or the next morning.
Did you get an address?
Yes, I did.
And where was that?
The address was 131 West 1st Street in San Diego.
Okay. FIR, First Street?
Correct.
Okay. And did you go to that address?
I did not, and the reason I didn't was because I had already been there previously in February, and it was a bad address.
Okay. Did you get any other addresses from the district attorney's office?
No, I did not.
And what did you do after the Lemon Grove attempt? And that was on April 12th?
Correct.
Okay.
On April 14th, I went to an address in San Diego, in downtown San Diego, that turned out to be a Russian restaurant.
Was that an address that you also got from an informant?
Yes.
What about after that, after April 14th? Or after that attempt at where you went to I guess you went to a Russian restaurant? What did you do after that?
I think that was my last attempt to actually look for Mr. Kavanaugh.
Did you ever conduct any surveillance to see whether Mr. Kavanaugh would turn up at any one of these addresses?
Yes, I did.
Where was that?
It was the Massachusetts address in Lemon Grove. I sat outside waiting to see if I saw anyone enter or leave that residence for several hours, and there was no activity.
And did you get any up-to-date work or employment addresses for Mr. Kavanaugh that you could attempt serving the subpoena?
Nothing up to date.
So as of today's date, have you been able to locate or get any leads on where Mr. Kavanaugh is?
No.
Nothing further.
Anything across?
Mr. Robertson, you indicated that your initial assignment to look for Mr. Kavanaugh began in August of 2017?
No.
When did your
I was
initial
giv-
assignment begin?
I'm sorry?
When did your initial assignment to look for him begin?
Well, I think as soon as I got tasked with investigating this crime back in April of 2016, he was part of the investigation, somebody that I knew I would need to talk to eventually. But there was a lot of other aspects to this investigation. So it took a little while to get to him.
Okay, so you're initially assigned to this investigation in 2016. When do you actually start looking for him?
Actively looking for him, besides making phone calls that were no longer any good, it would be in August of 2017.
Okay, so if your report says you didn't actively start looking for Kavanaugh until mid-February 2019, is that an error?
Well, I started looking for Mr. Kavanaugh back in August of 2017. In regards to this case for a subpoena, it was February 2019.
Okay, so you started looking for him in 2017, but you didn't actually start looking for him in regards to this case and actively looking for him until February of 2019.
For the subpoena service, correct.
Okay, and so were you aware as to when this trial actually started?
Yes,
Okay, and when did this trial start?
early January 2019.
And so prior to that, you actually had not gone down to San Diego to look for him, right?
That's correct.
And so you started looking in mid-February of 2019, but I see that you actually didn't go anywhere until February 23rd of 2019. Is that correct?
That is correct.
So that'd be more clearly the end of February of 2019, right?
Yes,
Okay, and so when you look at all the places you looked for about 6 days, is that right? Couple places on the 23rd, right?
that's correct.
One on the 24th,
Yes,
and one on March 1st, right?
yes,
And then you didn't do anything again until March 21st, right?
that is correct.
And at that point, the defense had already started their case, right?
I don't know when they started their defense.
Okay. And then you looked again on the 12th of April, right?
Yes,
And then again on the 14th, is that correct?
yes,
And you didn't look anywhere in Hawaii, did you?
Did I look in Hawaii?
Yes.
No.
But you had been given information and you had looked at information related to this case that Mr. Kavanaugh had previously been in Hawaii, right?
All I knew was that he was allegedly there during the disappearance of the family.
Okay. And you indicated that you looked at his Facebook page as well, right?
Yes.
And you're aware that his Facebook page says that he's located in San Francisco, right?
Objection,
Yes.
assumes facts not in evidence.
Overruled, yes, remand.
I have nothing further.
Anything on redirect?
Yes. Would it be fair to say that Mr. Kavanaugh's representations of what his addresses are incorrect?
Objection calls for speculation.
Sustained.
Well, was the San Francisco address a correct address?
Objection lacks foundation, he says he didn't check it out.
That
He
mistake.
didn't lay a foundation if he attempted to check that.
Did you check his address in the Bay Area that he had represented was his?
No.
Did you check any other addresses that, in Yuba City that were given to you?
Objection vague as to the city.
Overruled.
Was there an address given to you of Yuba City for Dan Kavanaugh?
I don't remember if that was given to me.
What was that? Was there an address given by the District Attorney's Office of Yuba City?
Objection, that lacks foundation and calls for speculation.
Overruled, you can answer if you know or not.
I don't know. I just know that when I made the request for the most current address of Mr. Kavanaugh for them on March 3rd of this year, that an address was given to me initially, but then it was corrected saying that that was not the right address, and they ended up giving me the First Street address in San Diego.
So at any time, did the prosecution ever give you an address of Hawaii for Dan Kavanaugh?
No.
Do you know how many requests were made of the District Attorney's Office for current location information for Mr. Kavanaugh?
Objection, relevance.
Sustained.
Did you, do anything between these dates that council was talking to you about? Is it that you just show up down in San Diego, for example? Are you doing work in between times to get potential location information?
Objection relevance.
Overruled.
I am just, when I am given an address, and most of this was given, a lot of it was given from my defense team, I will Google Earth it, map it, find out where it's at. But doing much more than that, driving down there, no.
How about talking with the informant? You obviously got the name of an informant, somebody that potentially had information about his whereabouts, is that correct?
Yes.
And so is that done when you're actually down in San Diego? Is that done in between the dates that you've mentioned so
Sexual
far?
relevance and beyond the scope.
Overruled.
That conversation was conducted over the phone, and I acted on that information after receiving it.
I think that's it. Thank you.
Anything else?
So to be clear, you requested information from the prosecution and you received a response almost immediately.
Yes.
Nothing further.
Anything else?
I do have one more question. You said you got information from the defense team, is that correct? On
Yeah.
how to proceed.
Yes.
So it would be fair to say that nobody from the defense team actually asked you to go subpoena Mr. Kavanaugh prior to trial, correct?
Objection beyond the scope.
And relevance.
Overruled, answer.
Can you repeat the question,
Sure.
please?
Counsel asked you about the start date of the trial, right?
Yes,
And you said you took direction from the defense team, is that correct?
yes,
Did anyone from the defense team ask you to go subpoena Mr. Kavanaugh prior to January? Not subpoena Deuce's Tecum, which is for documents, but to actually go subpoena the person to show up.
no,
And in your getting information from the defense team, there was a witness list provided by.
Objection, relevance, argumentative, violates the course of evidentiary ruling.
Overruled in light of the cross-examination.
You got information regarding the witness list that the prosecution provided, which had Mr. Kavanaugh's name on it, is that correct?
yes,
So, would it be fair to say in discussing that with the defense team that we relied on the prosecution's
Objection,
representation?
speculation,
Sustained call for, the objection sustained is calling for hearsay.
You were told by one member of the
Objection,
defense
same
team.
objection.
What he was told, sustained is hearsay.
Did myself or Mr. McGee tell you?
objection, hearsay.
Well,
Finish the question.
let me hear the question.
Did Mr. McGee or myself talk to you about Mr. Kavanaugh being on?
Objection, hearsay, relevance.
You already brought out the fact that Mr. Kavanaugh was on the district attorney's witness list. So, I think that answers the question as to why he started the work that he did when he did.
Thank you. So as the counsel had stated earlier, the defense case began sometime maybe March or late March. Do you recall her
Objection,
asking that?
speculation.
Actually, it's beyond the scope, cumulative, and relevance.
The objection sustained. Record speaks for itself on the defense part of
Sure.
this case.
Did it become apparent at some point that even though Mr. Kavanaugh was on the prosecution's witness list, that they weren't gonna call him?
Objection, relevance,
And-
argument, and speculation.
Sustained, and beyond the scope of what the court indicated was proper examination.
And you began, just to be clear, in, as counsel stated, in late February, so February 23rd, correct?
yes,
That was your first attempt.
correct.
Thank you.
Anything else?
No.
Okay, thank you. You can step down if you're still subject to recall, of course. So we'll recess until Monday. Let's see, tomorrow we had a juror who's not available, correct?
Yes.
Right, okay, so we'll recess until Monday, the 13th, and yes, that'll, we'll take care of, hopefully we'll have the tape ready to play, finish up with the detective and maybe a few other miscellaneous matters. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case or allow anyone to discuss the case with you or in your presence. And again, that means not discussing anything about the case, either witnesses, testimony, exhibits, parties, or attorneys. And we'll see everyone back on 9:30 Monday morning.
Is there any significance to the highlighted dates?
Now hear the thing.
Yeah, there's significance to them.
We're not here the 16th or the 20th.
Yeah, the 16th, we have, the 16th and the 20th, we have a couple of jurors who are not available those days, so we're not gonna be in session on those days. So we'll be in session on the 13th, and then probably not again until the 21st. And the reason for that is, there's one, as far as I know, there is one remaining, witness to be called by the defense. And, the defense is hoping that Mr. McGee will be available to do that witness and be available for any rebuttal and closing arguments. And so, given the other days that we're not going to be in session, we're really not losing that many additional days. So, if Mr. McGee is not able to continue on the 21st, then that'll also have given Mr. Moline the additional time necessary to get geared up to deal with the last witness and any rebuttal and things of that nature. So that's
So you said only the 13th for next week?
correct,
That's what I thought, not 14th or 15th?
correct. As far as I know right now.
Yeah, just the 13th.
Hmm?
Just Monday.
Just Monday.
One more time.
So we'll be here, as of right now, we'll be here on Monday, May 13th. And then we'll be back on May 21st.
For a half.
May 21st will be a full day. No?
It's a half day.
Oh, that's right, we had,
Yeah.
I didn't write that down on my calendar, but yes, we had someone who needs to be off in the morning or afternoon.
It'd be off in the afternoon.
Off in the afternoon.
Yeah.
Okay. So we'll be here on the morning of the 21st, and then the 22nd and 23rd, everyone can be here, right? Okay. All right, I think we're all on the same page. Okay? Thank you. I appreciate your patience. Councilor present, the jurors are not present. Yes.
I just wanted to highlight for the court, once again, shockingly, despite the court's evidentiary ruling on the scope of Mr. Robertson's testimony, counsel intentionally violated it by asking a question the court said it would not allow. I think the court needs to make sure that is on the front of its mind when making further evidentiary rulings in this case.
I am aware of that and corrected him in front of the jury on it.
Your Honor, I don't, if I did, I apologize, but I was going on the basis that the cross-examination opened up some
It
areas.
did open up the allowing you to present, to put on the evidence that Mr. Kavanaugh was on the DA's witness list. But to go beyond that and say, well, did we rely on that, and that's why you didn't do anything, that's clearly beyond the scope of testimony.
And if that's.
And I sustain the objection.
And if the court says that goes a little bit too far, I agree, but it's certainly not just violating it blatantly. I mean, they opened the door, I went in it, and I went through the door, I didn't.
Actually, it was. He paused, thought about how he was going to ask it,
All right,
and then sprung it. He didn't ask the court to approach. He did it on direct, then he did it on redirect.
And can I ask what question I asked that opened that door?
The questions highlighting that you didn't do anything to subpoena him until February of this year. Gives the suggestion that, well.
So it was a repetition of what was on direct.
Because that was on direct, Your Honor. That was exactly what he testified to.
Well, that is true. He indicated that's when he first did it, and I sustained the DA's objection on direct as an attempt to give an explanation of why he didn't do it beforehand. But then when you cross-examine in a manner that question, well, why didn't you do this earlier? That, in my mind, entitled the defense to say, well, he was on the DA's witness list. But to go beyond that and say, well, and we were under the impression they were gonna call him, and that's why we didn't do anything, and we relied on that, that was improper, and I sustain the objections.
Thank you, Your Honor.
Thank you, have a good weekend.